So we're going to talk to you a little bit today about the district attorney's office. The picture that you see up here, that's not my picture, but that is my boss. Summer Steffen is the DA. She's been the DA for a couple of years. She does a really great job, and hopefully y'all one day when we're not all in this COVID world, I can take you downtown to introduce you to her. She would love to meet you. So we're going to talk a little bit about the changing role in prosecution, because prosecution has changed a little bit over the years. But first, let's just talk about a few of the, let's see, how do I do this? Housekeeping rules. Hold on. Okay, so again, I'm Cheryl Suing Jones, and Taylor Williams is co-presenting. She introduced herself. I'm sure you'll love hearing from her, and she's willing to answer any questions that you have. All right, so again, we're going to talk about the overview of the criminal justice system and then do a virtual mock trial. So first, I'm going to show you just a little video that kind of gives an overview of what the DA does.
There's been a lot of attention on district attorneys lately and the prosecutor's role in the criminal justice system. But you might not know all the things the DA does, the limits on the DA's power, and the ways the DAs have already been changing their approach to prosecution in recent years. The DA's #1 responsibility is keeping our community safe. We do that in 3 basic ways that we call the 3 Ps. Prosecute criminals who break the law, work to prevent crimes from happening in the first place, and protect and support victims of crime and make sure their voices are heard. When you think of the DA, you probably think prosecutors. While that's a big part of our job, the power we have to hold criminals accountable is carefully defined by the law and our ethical responsibilities. When someone's arrested, we carefully review the facts and the evidence. We can only file the criminal charges we believe we can prove beyond a reasonable doubt. Our job includes protecting the rights of the innocent, as well as those we charge with a crime. Then, the case moves through the justice system, which provides checks and balances and accountability. Public defenders, criminal defense attorneys, and judges all play a role in how the case will resolve. Prosecutors alone don't determine a person's punishment if they're convicted. That's up to a judge and jury once we've proved our case. Our goal is always fair and equal justice for everyone, but also justice that's smart and reflects the needs of our society and the will of the people. As prosecutors, we also have the ability to give people second chances. That's why we work with special courts that steer people away from jail, still hold them accountable, but get them the help they need to break the cycle and stay out of jail. Help like mental health treatment, finding a place to live, or kicking a drug or alcohol addiction. We also support restorative justice programs that help offenders understand the harm that they've caused to a particular victim or community. That's one way we prevent crime, but there are lots of others. We work with youth to help them make good choices and stay in school. We support programs that help people who are coming out of prison to find jobs. And we let the public know how to recognize and report crimes like child abuse, elder abuse, sexual assault, and human trafficking. The third big part of our job is protecting and supporting victims of crime. In a typical year, the DA's office comes into contact with thousands of victims, and we help them in lots of ways. We help get them emotional support for the trauma they suffer from having a child or loved one murdered, or the emotional pain from a violent crime like rape. We help victims even when we can't file charges against the person who hurt them. We sometimes even use therapy dogs to help them testify in court and tell their story. Arf! We do all of this on behalf of you, the people. And we're accountable to you and to the laws of the state of California. Those laws are always changing to keep criminal justice priorities in line with changes in society and technology. We embrace reform, but we'll always work to make sure change happens in a way that continues to keep our neighborhoods and you safe.
Taylor?
Yes, hi.
Hi.
Okay, so I'm going to talk about what happens when someone commits a crime. So first 911 is called and someone reports that a crime has occurred, and the police officers will investigate. They'll interview witnesses. They will look for suspects, collect evidence, DNA, video surveillance, anything. And then they will eventually find somebody and hold someone accountable, and they'll arrest them for that crime. And a distinction is that if it's something very serious and very violent, then most likely they will go to jail, where they'll have to stay there until they can go before a judge. But sometimes when the crime is not as serious and not violent, then the officer will write them a citation and give them a date to appear in court. So after that all happens, the police officers send the reports to our office. And then from there, our office will decide, well, what kind of crime is it? And that's what's on our next slide, is that there are 3 different types of offenses. So it can be a felony, which is the most serious offense. That includes robbery. So if you walk up to somebody and say, hey, give me your iPhone right now or I'll shoot you, that's robbery. Burglary, if you break into someone's home. And when I say you, I don't mean any of you. I don't mean any of you out there. I just mean,
yeah, we hope not.
Yeah, no.
This is not y'all.
No. Another felony includes something like rape, murder, and sale of narcotics. So they're very serious offenses. Then you have misdemeanor crimes, and that's something that I work on since I'm a newer attorney in my office. I work on misdemeanor crimes, which are kind of like every day. So, when someone steals some food from Target, or they steal some jackets from JCPenney's, or they drive while being under the influence of alcohol, if they hit someone's car and they run, all those are misdemeanor crimes. And most likely, those are the crimes that an officer will just write a citation and tell you what day to appear in court. And then there are infractions, and that's lower than a misdemeanor. That's as low as it can get when it comes to a crime. And that is like a speeding ticket or driving without a license, just very low level crimes. And for that, you also will get a date to appear in court.
Let's see, sorry.
So after the DAs determine what kind of crime it is, we will review the police reports that the officers send to our office, and then we will decide what crime we'll charge, felony, misdemeanor, or infraction. And then when we look at every case, we think about who we are protecting. We think about the community, and we think about the victim of the crime, and we make decisions based off of that. And these decisions are very difficult. Sometimes we have to consider all sorts of things, and we'll get to an example of that just in a moment. Okay, so after someone is arrested, their first court appearance is the arraignment. That is the first court appearance in this criminal justice proceeding after someone has been arrested for a crime. This is the first opportunity for the person to be before the judge and plead guilty or not guilty to the charge. And it's also the first opportunity for the judge to tell the person what crimes they're being charged with. So the law says if the person is in custody, so if the officer took them to jail, then the court has 72 hours. Not the court, the DA's office has 72 hours to bring charges against this person. And so if this person was just given a ticket to go to court, then they'll show up, they'll walk in, and the judge will tell them the charges against them, and they can plead guilty or not guilty, and the judge will appoint an attorney to them. A lot of people get public defenders because they can't afford a private attorney, and public defenders are just fine. They're great attorneys, and they do a good job. And so people are appointed an attorney so that they can go through this criminal justice process with some legal assistance.
And then the judge can set bail and set future dates for them to come back. You guys have probably heard of bail, right? All right, so there are different roles that different people play different roles in the criminal justice. And so I'm going to talk to you, Taylor and I are going to talk to you about a little bit about the different roles that people play. So both she and I are district attorneys or deputy district attorneys. And what we do is we prosecute adult criminals who break the law, and we seek to rehabilitate juveniles who break the law. So an adult defendant is called a defendant. A child who breaks the law is considered a minor. And we work with them as minors and try to redirect them. So, and a lot of what we do is preventing crimes from happening in the first place. And that's why I meet with people like you, and I talk to kids any chance I get, because I want to tell people early the things that they can do to avoid getting in trouble to begin with. We also work to protect and support victims. So if you are the victim of a crime, our office will provide resources for you. And then we also partnership with the community that we serve. So prosecutors, we are very happy. And when I said the changing role of the prosecutor, prosecutors used to be thought of as just people that locked other people up for committing crimes. But we have certainly learned that we can't prosecute our way out of all the problems that happen in society. And so we are really about the business of giving people second chances. So we have special courts that can steer people away from jail, still hold them accountable if they do something wrong, but give them a chance, give them second chances in a way to break the cycle. Many people who end up getting involved in the criminal justice system have mental health issues. And so we want to make sure those people have opportunity to get mental health treatment. There are oftentimes people are committing crimes because they don't have anywhere to live. And so we have resources to help people find places to live and to help them to kick drug or alcohol addictions, because those are also major causes for people to get involved in crimes. In doing that, we have collaborative courts. So there's just a regular court where you commit a crime, you go to court, you get found guilty or innocent. If you're found guilty, you pay a price for it. But we also have some other ways that we try to help people so that they don't end up in the criminal justice system, but they get the help that they need, like drug court. If somebody is using drugs and that's why they are committing crimes, and we give them an opportunity and to go to drug court. So they still have to stay clean. They might have to test regularly, but if they succeed at drug court, then they could have their cases dismissed, and then they don't end up with a record. There's also courts for people who are homeless or that have behavioral issues. We have opportunities for people to re-enter into regular society once they have committed a crime, so that they can become law-abiding in the future. There are some veterans who, because they have been to war or are suffering from post-traumatic stress, if they can show that their crime was because of a mental illness that came from being in the service, then they can participate in treatment court. And then, of course, we want to help people when they get released back to the community. So again, they can go back to being law-abiding citizens.
So we talked a little bit about minors and adults, and in the criminal justice system, people who are 18 years and younger are considered minors, and they are treated differently in our criminal justice system. And our office treats them differently because our goal is not to punish them, but it's to rehabilitate them, redirect them, and get them on the right path before they become adults and make serious decisions that can affect them for the rest of their lives. So in our office, we have a juvenile diversion initiative, which is designed to take the lower level offenses that youth will commit and steer them out of the criminal justice system. Well, what do you mean? Well, for example, sometimes juveniles, people under 18, will bring knives to school. And so some people say that they do it for protection. Other people say that they just have it on them because it looks cool. Whatever the excuse is, it's against the law and it's dangerous. You can't take a knife to school. Well, we don't want to saddle this person with a criminal record that will hurt them for the rest of their lives, especially thinking about minority persons, right? We know what a charge like that can do to them for the rest of their life. So what we would do is create some sort of alternative to punishment that's appropriate for someone who brings a knife to school and needs a reminder that that's not okay and you can't do that. Our Juvenile Diversion Initiative partners with community-based organizations. So we want our youth to be a part of their community. So we'll partner with different outreach programs that can get this youth back into their community. So maybe they'll think about how their crimes or their actions can affect the people that they live amongst. So that's just a little bit about our juvenile initiative. The biggest thing that I want you to remember is that our office does provide second chances, and especially for our juveniles, because we want them to get it right.
So we talked a little bit about the role about defense attorneys. So Taylor and I are prosecutors. So we prosecute cases, and then there are defense attorneys who, if someone commits a crime, everyone has a right to be defended by a competent lawyer. And so there are different kinds of lawyers. There are public defenders if you can't afford to pay for a lawyer. And sometimes public defenders get a bad rap. It's not justified. Public defenders, as Taylor said, do a great job. But what a defense attorney does, whether it's a private lawyer or a public defender, is they provide legal representation and they give people advice. So if someone has been charged with a crime, then they need someone to help them understand what the crime is, what the potential defenses are. They will go with the person that's been charged to court, and they will be the one that will interact with the judge. They will interact with us as DAs to get for the hearings. That there are many hearings that happen in a court in front of a judge between the time that you go the first time and the time that you are found either not guilty or guilty. They'll help prepare a defense. They will conduct legal research. They will gather facts and interview clients and witnesses. And then they will work with a defendant to talk about strategies and a defense. And then there is the judge. So the judge is the person who presides over the proceedings and makes sure that order is maintained. So she's the one who determines whether or not the evidence that the lawyers want to put on is legal or proper. Like, we can't just go into court and stand up and say what we want, what we think, or something like that, or what we heard somebody say. There are rules about how to put on cases. And so the judge is there to make sure that the rules get followed. And she's also there to give the instructions about what law applies to the case. So you don't have to figure out whether or not, if you're a juror, you don't have to figure out like whether or not you think this is right or wrong. There are rules that tell you what is legal and what's not legal. And then if a defendant is convicted, then the judge is the one to sentence the defendant.
So there are other players that are a part of the criminal justice system, and in the courtroom, we have the jury. So that is the jury of our peers. This is people from the community that get a jury summons. Then there's also the court reporter, and he or she is the person that writes down everything that's going on and that's said inside of the courtroom. And that's a very important job because we have to have a record of what happens inside of the courtroom. So, you know, sometimes when you hear people say, "for the record," well, they're talking about that transcript that's created and typed up by the court reporter. Then we also have a court interpreter, and those are very important, especially to us in San Diego. We have a lot of Spanish speakers, and so the court will have a court reporter on hand, ready to go and ready to assist people that have a language barrier. And then there's the courtroom clerk, and that is the judge's right-hand person. That person organizes all of the minutes, all of the cases that come through the courtroom that day, and the judge really relies on the courtroom clerk. It's a very difficult job, but a very important one. All right, so we have a little bit of an activity for you all, and we really would like you to be involved because this will help you understand what it's like to be a prosecutor and just understand a little bit more about the decisions that we have to make. So we're gonna do a case study, and you are the prosecutor. And at the end of this, I wanna know what you will do. So put it in the chat. All right, Mary is on vacation and comes home to find her back door is broken, the TV is on, lots of snacks in the kitchen are out of place and appear eaten. A stranger, John, is asleep on her couch, wearing her husband's clothing. Mary calls the police and John is arrested. Aside from the food, none of her personal items were missing. The cost to repair the broken door is about $200. A review of John's criminal history shows that he's been convicted many times of drug-related incidences. And once he was convicted of a robbery. The police forward the police reports to the district attorney's office, to the prosecutor to decide what are we going to do. Are you going to charge John with a crime? So first, we have to decide, is this a case that we want to file charges on? And then second, we have to decide what charges are we going to bring? Are we going to bring misdemeanor vandalism, which is the broken door? Or are we going to charge him with theft for the food that he took and ate? Or are we going to charge him with a residential burglary, which is a felony for breaking and entering into her house with the intent to steal? So I want to hear from you guys. 1, 2, or 3. What are you as the prosecutor going to do?
So you want them to respond in the chat. Are they also able to come off mute if they want to respond verbally?
Yes.
We would love for them to come off mute and respond verbally. That's what we would love to happen. So, or hold up a finger, you know, hold up 1, 2, 3, something.
We got 1, 2, and 3 in the chat.
Yes, we have different ideas. Okay, so I'm going to start with number 1. Halima, tell me why you would reject this case and not have the case at all.
Well, it doesn't really seem like he's trying to hurt anybody because he just like ate food and then kind of stole their clothes. So it kind of sounds like maybe he doesn't have a home and maybe he kind of like, he needs a little bit more help. So putting him in jail or anything like that wouldn't really help him. And if he got out, he might just do the same thing.
Love, that's lovely. You sound like an attorney. Those are very good considerations and all things that we have to think about. Now let's hear from Deanna. Why would you charge him with, well, first I want to hear, Deanna, are you charging him with the vandalism or are you charging him with the theft of the food?
The vandalism.
Okay. All right. Because of the broken door and the repairs that cost $200.
Correct.
Well, Deanna, but what about his drug issue? I mean, he must have been, you know, under the influence at the time that this went on, and he didn't mean to do that.
Right. I get that we can get him the help for that, but you know, the door, that's going to cost me money.
Okay.
Sorry.
Now, Tasha, tell me why you would charge him with the felony for breaking and entering into Mary's home.
I would charge him with a felony because he broke into my house without my permission and went into my like cabinet of food that like I probably just bought and is wearing my husband's clothes.
Yeah, it's an invasion of your privacy. Could you imagine coming home and there's someone in your bed wearing your family member's clothing? Oh, just thinking about it, you feel violated. And you know what? Mary probably feels scared. She feels scared that this might happen again. She feels like this person knows where she lives. This person knows how to get in. And this person, like Halima said, might do it again. And so what about Mary? What about Mary in all of this? And so I just want to hear from maybe one more person. Dorica, tell me if you're charging misdemeanor vandalism for the broken door or for the food.
I would charge him for the vandalism because like charging for him like breaking in like what Halima said, like he could have like needed something, so like you have to take that in consideration, but at the same time like he did break my door, so I would want that to get replaced.
Now, do you see like all these considerations that we're talking about? We're thinking about his drug issue. We're thinking about Mary and her broken door. We're thinking about the possibility of this happening again. You know, we're thinking about felony or misdemeanor. All these decisions we've got to make within 72 hours. And we've got to figure out what is the right thing to do to, one, protect the community, protect Mary. What do we have to do to make sure this doesn't happen again? And what do we have to do to help the defendant, John, who clearly needs some assistance? What do we got to do? And so I want you to know that there's not necessarily a right answer, right? It's up to the prosecutor on what she will decide. And that's why we need diverse persons like you all in our office, because you see, we all come up with different things, right? And we all have a version of what's the right thing to do for John. And I think that's like the one of the reasons why I got into this job and why I became a prosecutor, is because I have the power to make that decision. And I have the power to help John in whichever way I see fit while still helping Mary and protecting the community. So great job, everybody.
Thanks. And one thing I wanted to add to that is that, so we're giving you these little short fact patterns, but in a real case, you would have a lot more details. So you might have more how much trauma the victim incurred, how much effort he went to break in. You might have more information about the defendant to know whether or not this is somebody that you do want to give a second chance to. So because like I said, our office is about giving people second chances. So if this is someone's first offense, they're somebody that we might give a second chance to. So if this is something they've been doing repeatedly, then those are all things we take into consideration. Okay, so we have another fact pattern here. So, okay, so Jose has owned a small convenience store for many years. With the money earned, he can barely afford to pay rent and his children's school supplies. Late one night, two 20-year-old boys come into the store, walk straight to the liquor aisle, grab one case of beer, and ran toward the exit. Jose was working by himself and chased them. He caught up with one of them, Tom, and grabbed Tom's arm, but Tom pushed Jose's hand off him and kept running forward. Jose, who owns the store, fell to the floor. With the surveillance video footage, the police were able to identify Tom. Tom admits that he is in the video, but denies causing Jose to fall. The cost of the case of beer was $20. Jose's knee still hurts from the fall, but he doesn't have medical insurance and he hasn't seen a doctor. Tom's criminal history shows he is currently on DUI probation, that's driving under the influence, for a DUI that happened a few months ago. Police send the reports and video to you. What do you do? So Taylor, I want you to help me with this part because I can't see the chat. So I
Okay.
can't see what people wrote. But the three options are: one, reject the case, no charges filed, or charge battery and petty theft, which are both misdemeanors. And battery is the willful use of force or violence upon another person. So you don't have to have hurt that person, or certainly you don't have to have hurt them badly. But if you push someone and they're there and you do it intentionally, that's a battery. And then, of course, we have potentially a felony robbery. And so robbery is using force or fear to take the property of another person. And so just to go back real quick, so just so you know what we're looking at to determine which of those. So when Jose chased Tom and grabbed him, but then Tom pushed Jose's hand off and fell to the ground, that could be considered sufficient force for a robbery. Of course, you could also charge it as a battery, which is a misdemeanor. These are considerations that we have. So we would like to know what you all think we should.
It looks like Mona and Evelyn believe that we should charge a battery and a petty theft. Mona, can you tell us why?
I mean, because he literally grabbed the beer and ran out of the store without paying, and then he pushed him on the floor purposely to try and get away. So of course it's like a battery for pushing him. So
Mona, do you think we should charge a robbery then, since you talked about how he pushed Jose to get away with the property?
yeah.
Okay, now that's a felony. That's different than a misdemeanor.
One of the differences between a misdemeanor and a felony is that if you are convicted of a misdemeanor, you could go to jail. And jail is local, like George Bailey, Las Colinas, those are jails. If you can get convicted of a felony, you could go to prison. And so like Donovan is a prison. So there are different punishments for, and you could only go to, if you go to jail, it can only be for up to 364 days. But if you go to prison, it could be a year, 16 months, 2 years, 3 years, 10 years, depending on how serious the felony is. So those are also considerations that you might think about when you're making that a charging decision.
Justin, tell us why you changed your mind.
Because I feel like he intentionally pushed them off just to run away with the $20 beer. So I think charging him with the felony, he should like do the right.
Good comments, great considerations.
Okay. All right. And so I think we already did the why. So where are we here? So Readiness Conference. Taylor?
Yes. I was just reading a comment from Rob in the chat, and Rob was saying that he would love to see a restorative justice option for Tom and Jose. What restorative justice is an opportunity for Tom to sit down with Jose, maybe even apologize and explain why he did what he did, and for Jose to explain how what Tom did hurt him in some way. And we do have those avenues for restorative justice. That is another way that our office tries to take cases out of the criminal justice system, handle them between, two civilians, and we mediate that, if you will, because we feel like an apology goes much further than a charge sometimes. But that's not always an option that we have, right, Rob? Because, Jose did suffer injury. And so what if Jose doesn't want that as an option? What if Jose doesn't want an apology and Jose wants justice? He wants him to go away for a little bit. So we have to balance that too. But I think that's a really good point, Rob, and that's something that our office has and something that we do consider.
That is an excellent, Rob.
A readiness conference is where we would talk about options like restorative justice, or we would talk about, things from Tom's background that may have made him do what he did on that particular day. We'll also, it's a chance for the defense attorney and the prosecutor to sit down and talk about the case and figure out what's really going on and what is the right thing to do in this case. It's very collaborative. It's a discussion, really. And then you also have the judge there who, Cheryl, what would you say the judge role is in the readiness conference?
The judge is kind of a mediator. So he will, or she will, listen to the prosecution, give just a very brief synopsis of what happened, and the defense might also give what the defense is. And so the judge is usually pushing us both to resolve the case. So if the defense makes an offer to plead, let's say if the defense makes an offer to plead to the misdemeanor, and we want them to plead to the felony. So the judge might look at it herself and think, based upon this person having, no record, I really think a misdemeanor is sufficient. Or they might say, defense attorney, this person has committed a lot of other crimes. They've had an opportunity before, and they have, every time we give them a chance, they come and do it again. So maybe it's time for a felony. So now what the judge doesn't determine what the person is going to plead to, but they're really kind of being the referee and trying to get us to come to some kind of an agreement, because we can't take every case that comes before us to trial. It's not reasonable. So the judge is, like I said, kind of a referee.
And then that takes us to the guilty plea. So a lot of our cases result in a guilty plea and they don't get to trial. And that's because people take responsibility for their actions. They're held accountable. But also they're given the opportunity to plead guilty prior to trial. So they don't have to go all the way to trial. And Cheryl, I forget the percentage, but what is the percentage of cases plead guilty before going to trial?
I think it's about 90% of them actually plead
Yes.
guilty before going to trial.
Yes, you're right. And so it's up to the prosecutor to make sure we're offering fair and just deals prior to trial, given the fact that the majority of these cases will plead prior to trial. So a guilty plea, it really just consists of, again, the defendant taking responsibility, and he will admit the charges. And most of the times, like a plea bargain is the defendant pleading guilty to something less than what we have charged him with. So you remember the case of Mary, where John was in her house while she was on vacation, and we could have charged him with the vandalism, broken door, and we could charge him with the petty theft. So that's 2 charges. So a plea deal for John would be plead guilty to the vandalism so that you can pay the restitution, the $200 that's owed to Mary. That's what a plea would be, is he wouldn't have to plead to both of those counts, just one. I hope that makes sense.
All right, and then again, it says the judge must approve of it. So.
Okay, so then that takes us to the jury trial. Every person has the right to a speedy jury trial, and it's a search for the truth. It is the opportunity for the prosecutor to present evidence that proves beyond a reasonable doubt that the defendant is guilty of the charged crime. The jury trial happens in a courtroom before 12 jurors of our peers and a judge. Jury trials are open to the public anyone can attend a jury trial. And after the prosecutor presents her evidence and the defense presents their evidence, the jury will determine whether or not the defendant is guilty of the charges and whether or not the people have proved beyond a reasonable doubt that the defendant is guilty.
Okay, so now we are going to have a virtual mock trial. This is the people versus, okay, this is covering up, Mr. Tony Finwicki. So you see there are various people that are sitting in different places in the court. You see the judge sits at the behind the bench, and then the witnesses will sit to the right of the judge, and the clerk sits to the left of the judge, and then there's the jury sits here in the jury box. The DA sits closest to the jury box, whichever side of the court the jury box is on. The defense sits on the other side, and then other people that are able to come and watch the trial sit in the back. Now we're in COVID right now, and so I don't think there are other people that are allowed to come into court, but you can watch any court trial on a YouTube channel. So let's talk about that afterwards if you want to do that, and I can maybe help direct you how to do that. But we're going to go through this mock trial.
All right, so for jury selection, only certain people are eligible to serve on a jury. You have to be a US citizen, 18 years old, live in California, are a resident of the county within you receive the jurisdiction or receive the jury summons, and you can understand English all right. You're not currently serving on a jury or a grand jury, and you're not under conservatorship. And you haven't had your civil rights restored if you've been convicted of a felony or malfeasance while holding public office. Okay, next slide.
All right, so in terms of jury selection, so what jury selection is, so I know that Taylor probably told you, I had to step away for a quick second, but that the lawyers pick a jury. And so, but there are rules that happen about how we pick a jury. So we'll have maybe 50 people come in, and we're trying to agree upon 12 people to be in the jury. So there's 12 jurors and sometimes between 2 and 4 alternates. And so there are different ways that we get to look at who we want to keep on the jury and who we want to leave the jury. So for starters, what we're looking for is jurors that can be fair and impartial. We can't exclude based on race, sex, ethnicity, or any of those type of bias things. We do take into consideration if jurors have like a hardship. So a hardship could be something like they're a full-time caretaker for someone who needs to be there to, they need to be there to take care of them, or they're not going to get paid for it. And so there's different kind of, they call them challenges. So reasons that we can ask for someone to be excused from a jury. So for instance, if it's for cause, it could be if maybe the juror knows someone that's on the case, or maybe they've had some prior life experience, like if someone has been a victim of a battery recently and they're still traumatized about that, they might not be able to listen to a case about battery and be fair. And then there are other times where we have a certain number of kicks that we can do that are called preemptory challenges. And that's just if we just don't get a good feeling about them. They say something that makes us uncomfortable. But again, our bad feeling can't be based on their race, ethnicity, or sex. Okay. So you've been selected for jury duty, and we're going to put on our case for you.
All rise. The Honorable Judge Jones now presiding in the case of the People versus Finwicki.
Okay, and you see this beautiful judge. That could be any of you. Any of you can grow up and become an attorney or a judge. So let's talk a little bit about juror rules.
Yes. So once you are selected as a juror, the judge will read to you the rules of being a juror. Now, I want to read them to you, and I want to know what you think about them. So put in the chat what you think about these rules. So the judge will say, do not make up your mind about the verdict or any other issue until you have discussed the case with the other jurors during deliberations. You cannot consider punishment. It is not up to you whether the defendant will be put in prison, in jail, or serve no time at all. You cannot consider punishment. That is for the judge to do. You're not allowed to do any outside research. No Google, no Bing, no texting friends, reading books, finding out about this issue. No outside research. You can only use your own knowledge and lived experiences when in the jury deliberation room. Keep an open mind throughout the trial. Do not make up your mind at the beginning of the trial. Listen to all the facts and all of the evidence before making a decision. Do not let your bias, sympathy, prejudice, or public opinion influence your assessment of the evidence or your decision. You cannot be biased in favor of or against any party, witness, attorney, defendant, or alleged victim because of her or his disability, gender, nationality, national origin, race, ethnicity, religion, gender, identity, social or sexual orientation, age, or social economic status. That is what the judge will read to you when you are a juror. What do you think about those rules? Did you know you're not allowed to consider punishment when you're a juror? I didn't know that. I learned that when I became an attorney in this job. I said, oh, I didn't know the jurors don't get to find out what happens to the defendant. And it should be that way. It's the law. So you're right.
All right, so I am going to play the prosecutor in the case. So I'm making my opening argument before the jury. So assuming that that a jury has been picked, you all are all on the jury, you're sitting in the jury box. And before I put on witnesses, I get to give sort of an overview of what the case is about. And so this is, whoops. All right, so I am pushing buttons. Okay. So Mr. Wiley is the neighborhood grouch. And the defendant, Mr. Finwicki, had an axe to grind. Mr. Finwicki threw a rock at Mr. Wiley's window and it shattered. A mail carrier saw the defendant, and the defendant is Mr. Finwicki, saw the defendant holding a rock right afterwards. So we know that the window was shattered and that we know that Mr. Finwicki was holding the rock. And so I am asking you at the end of this trial, after you've heard from the witnesses, I'm going to ask you to find the defendant guilty of vandalism. All righty. So
now it's my turn as the defense attorney to give my opening statement. And I will tell the jurors and all of you that there were 10 people there. And none of the witnesses, not one, saw my client throw the rock in the window. There's no evidence that Mr. Finwicki threw the rock. At the end of this trial, members of the jury, you must find him not guilty. Thank you.
Okay, so because the prosecutor, I have the burden of proof. I have to prove the case beyond a reasonable doubt. Our defense attorney, Ms. Taylor, doesn't have to prove anything. She can put on a case if she wants, but she doesn't have to prove. But I get to go first. So here's my evidence. Okay, so Mr. Wiley, this is our victim. And he's a person who owns the house. It was his window that was shattered. So he testifies, I have lived in this neighborhood for 20 years. And over the years, I have been a victim of many attacks of vandalism. On Friday evening, March 15th, I was watching the 6 p.m. news when I heard glass breaking. I ran out my back door and around the house to see what was going on. I saw a lot of people. I recognized Tony. Now, Tony is Mr. Finwicky because he lives down the block and often rides his bike past my house. Tony even had a rock in his hand and was getting ready to throw it. It cost $550 to replace my window. So then we need to have witnesses, to have someone, if there's anybody around who might have seen something, then we will call those witnesses. We will send a subpoena for them to come to court to testify. So the mail carrier is our first witness. And the mail carrier, Leslie, says, I have delivered newspapers to Mr. Wiley's neighborhood for 3 years. On Friday, March 15th, I was delivering mail 3 houses away. I heard people yelling, and then I heard breaking glass, and I ran over to Mr. Wiley's house. I saw about 10 people on the front yard. Defendant and another guy were pushing each other. It looked to me like the other guy was trying to stop the defendant from throwing a stone. The defendant had a rock in his hand, but I didn't see anyone throw stones. And then I'm going to call the law enforcement officer, because for us to prosecute a crime, there has to be, the police officers have to go to the scene and file a report. So they file the report, they submit it to us. We review the report and make charging decisions like you all just did a few minutes ago. So officer is going to come and so she's going to testify that she went to the scene, she took photos of the defendant's hands, the rock, and the window. And again, defendant is Tony. And that Tony was the only person who stuck around and he was holding the rock. All the other people ran away. She'll tell you there was no DNA or fingerprints on the rock because the rock was dirty and rough. And there's no surveillance at Mr. Wiley's house. She'll also tell you she did a search warrant of the defendant's Twitter page and found postings about Mr. Wiley. So when you're putting on evidence, you not only put on people talking, but if you have any kind of photos that help tell the story, that's always makes a more compelling story, because then the jury can, pretty much visualize what happened. So the police officer took a picture of the defendant's hands, which you can see here are very dirty. She took a picture of the rock. You can see that it's got rough edges. So even if there were fingerprints, you might have a hard time pulling them. If it was a smooth rock, you would have a better chance of getting DNA or fingerprints. And then, of course, we have the photo of the broken window. And then remember when I talked to you last week, I talked about how things that you put on social media, things that you print out there can sometimes be used against you. Well, in this kind of a case, it can be used against Tony. You'll still have a chance to decide what you want to make of this evidence. But you look on his Twitter feed and you see that Tony wrote neighbors. Can't live with him, can't live without him. He's like, wait, no, I can live without him. And then somehow he's got these matches that are on fire, which suggests he really doesn't like the victim. And then we've got another Twitter that says, on today's edition of Wiley the Whiner, I left my bike near his house. Wah! So, and then we have another one that says, Mr. Wiley is the worst. He's got to pay. Who's with me? A big sign that says, worst neighbor ever lives. So from the admitting that he left his bike at the house, he is admitting that he was there, but he's not admitting that he did anything wrong. So that's the people's evidence.
Friend's case.
So the defense attorney puts their case on.
Yes. After the prosecutor goes, then it's my chance to put on witnesses or do nothing at all, because it's not my job to prove this case. It's the prosecutor. All I have to do is point out the holes in the case. All right, so the first person that we have in our case is Sandy. Sandy will come in and testify that she was hanging out with the defendant at his house on Friday night. And some friends decided to go ride their bikes, doing tricks in the street. A bunch of guys showed up and they dared the defendant to throw a rock at Mr. Wiley's house. The defendant ignored him. Then those guys that showed up threw a rock and broke some of Mr. Wiley's windows. The defendant tried to stop them, but couldn't. Sandy is dating our defendant.
So one of the things that as the prosecutor, when I go to make my closing arguments, or even when I cross-examine Sandy, I'm going to be bringing it to your attention that Sandy is the defendant's girlfriend. And so she might have a reason to lie for his benefit. So as opposed to an independent witness, someone who just happened along, she might have a reason to not be honest. Now, that doesn't mean she isn't honest at all, but that's a part of the considerations that we make with witnesses and a part of what we're thinking about when we're questioning them. So Taylor's going to put Sandy on to say that the defendant didn't do it, but I'm going to bring to your attention that she is his girlfriend. So you might think about how much of that you believe.
All right, and then we have the defendant himself, Tony. He will testify that he didn't throw anything. He was riding his bikes with some friends on Friday night. And right as it was getting dark, a bunch of guys rode up and started messing with the defendant. The defendant, or the guys that showed up, wanted to throw rocks at people's houses, including my neighbor, Mr. Wiley's house. I don't like Mr. Wiley, but I wouldn't throw a rock at his house. Mr. Wiley doesn't get along with anyone on the street. The defendant will say that he saw a guy grab a rock and the defendant tried to stop him, probably how his hands got dirty. The defendant will say that that guy pushed him to the ground, again, making his hands dirty, but the defendant had the rock in his hand. And then when Mr. Wiley came outside, Mr. Wiley blamed the defendant. So it's really important to know that the defendant does not have to testify. He has a right to not testify against himself in his trial. Again, it's up to the prosecutor to prove this case beyond a reasonable doubt. So the defendant doesn't have to prove that he's innocent. The prosecutor has to prove that he's guilty. But in our case, Tony wanted to take the stand to prove his innocence.
Okay, so after you hear from all the prosecution witnesses and all the defense witnesses, then the lawyers make a closing argument and we sort of summarize the case before we ask you to make a decision. So I'm standing as the prosecutor and I'm going to stand there and I'm going to say the defendant had dirty hands. He had a rock in his hand when he was contacted by the police. We know he has a motive to do this because he doesn't like Mr. Wiley. We know he doesn't like Mr. Wiley because all of the things that he put on Twitter, and he made veiled threats. He even posted that picture of those matches on fire to suggest that he intended to do Mr. Wiley harm. So for those reasons, I'm asking you to find the defendant guilty of the crimes charged.
Members of the jury, not one person saw my client throw a rock at Mr. Wiley's house. Both the defendant and his girlfriend said that someone else did it. Some other guys who were in the neighborhood causing trouble. You heard Tony. He said he wouldn't do that to Mr. Wiley. Yeah, they don't get along, but he wouldn't throw a rock at his house. And you see from the prosecutor's evidence that he's got dirt, that Tony has dirt on his hands and dirt on his knees, which is consistent with his testimony and his girlfriend's testimony that he fell and that he was trying to stop those people from throwing rocks. That's how he got dirty, and that's how the rock ended up in his hand. But it certainly wasn't because he threw it at Mr. Wiley's house. The prosecutor has failed to prove that the defendant threw the rock at Mr. Wiley's house. And it's for those reasons that I'm asking you to find him not guilty.
Okay, so once you hear all of the evidence, then you or the jury, you go back into a room and you deliberate. So you sit around a table, you're going to sit around a table and you're going to talk about the evidence. And you have to make a unanimous decision. So either you will unanimously decide guilty or you will unanimously decide not guilty. And if you can't decide, then it's going to be what's considered a hung trial. And so then it will result in a mistrial, and we may have to try the case all over again. So, but before you go back there, you're going to get some rules about how to look at the evidence. Madam Judge is going to read you the jury instructions. Taylor?
Okay, the judge will read, a defendant in a criminal case is presumed to be innocent. This presumption requires that the people prove a defendant guilty beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt, because everything in life is open to some possible or imaginary doubt. In deciding whether the people have proved their case beyond a reasonable doubt, you must impartially compare and consider all of the evidence that was received throughout the entire trial. Unless the evidence proves the defendant guilty beyond a reasonable doubt, he is entitled to an acquittal, and you must find him not guilty. Vandalism requires that the people prove, 1, the defendant maliciously damaged property, and 2, that the defendant did not own the property. Someone acts maliciously when he or she intentionally does a wrongful act, or when he or she acts with the unlawful intent to annoy or injure someone else. All right, jury, it's time for you to vote. It's time for you to decide whether you think the defendant is guilty or not guilty. So you can put it in the chat, or you can come off of mute and tell us why you think the defendant is guilty or not guilty.
And you see the round 1 here, because usually it takes a few go rounds for a jury to agree upon guilt or not guilt. So they will maybe the first time they may talk among themselves and then do a vote. But when they do the first vote, it might be 7 for guilty, 5 for not guilty, or 6 for guilty, 6 for not guilty. So let's talk about round 1. And this would be the verdict that you give before you all talk to each other and get your ideas. So
Victoria and Stacy think not guilty.
Okay.
Why do you think that, Stacy?
I don't think that enough evidence was shown to convict him of a guilty verdict. No one actually saw him throw it. He had a rock in his hand. It wasn't the rock that went through the window. I don't think there was enough people that saw him, which I don't know how so many people can be around after you throw it and not while you throw it. So I say not guilty.
Okay, does anyone agree or disagree?
Jarika agrees, Deanna agrees, Layara agrees. Does anyone think he's guilty? And it's okay if you do. Well, it looks like, Cheryl, they all think he's not guilty.
Okay, so then if they vote the first time, then we maybe don't need a second time. But what typically happens is that you'll have some back and forth. You'll have some people that are saying, well, we didn't see him with the rock in his hand, but he was standing there and somebody threw the rock and he was the only one that was still there with the rock, and all those other people ran because they ran because they didn't want to get implicated for something they didn't do. But you'll have a jury going back and forth, and ultimately the jury decides. So and sometimes there is a second round, but if anybody had to make an argument for why he was guilty, like, is anybody willing to make their argument? And let's say you don't really think they're guilty, but just so that we can hear another perspective. If you had to argue that he was guilty, what would you say? Can anybody answer that? Thank you so much for coming. I hope to see you guys again soon. Have a good weekend. Anything else?
To the presenters for presenting us with a great presentation, for giving them some insight on what you guys do.
You're very welcome. It's our pleasure.
Yes.
And that is all, folks.
Yes, and with that, everyone enjoy their Friday and your weekend, and we'll see you next time.